Act Number 1696 or the Flag Law of 1907 and Act Number 518 or the Brigandage Law of 1902. The Flag Law of 1907. In August 1907, few months before the formal inauguration of the Philippine Legislatures' lower house to be composed exclusively of Filipino lawmakers, another direct assault was sustained by the nationalist and the pro-independence efforts in the Philippines. A new legislation was enacted by the All-American Philippine Commission, which is the Act Number 1696, or the Flag Law of 1907, an act to prohibit the display of flags, banners, emblems, or devices used in the Philippine Islands for the purpose of rebellion or insurrection against the authority of the United States and the display of Katipunan flags, banners, emblems, or devices and for other purposes. We have 4 sections under the Act Number 1696. Section 1. Any person who shall expose or cause or permit to be exposed to public view on his own premises, or who shall expose or cause to be exposed to public view either on his own premises or elsewhere any flag, banner, emblem, or device used during the late insurrection in the Philippine Islands to designate or identify those in armed rebellion against the United States, or any flag, banner, emblem, or device used to or adopted at any time by the public enemies or of the United States in the Philippine Islands for the purposes of public disorder or of rebellion or insurrection against the authority of the United States in the Philippine Islands, or any flag, banner, emblem, or device of the Katipunan Society shall be punished by a fine of not less than 500 pesos nor more than 5,000 pesos, or by imprisonment for not less than 3 months nor more than 5 years, or both by such fine and imprisonment in the discretion of the court. Section 2. Any person or persons having charge at any bank violations, entertainment, public meeting or reunion, or any parade, procession, or review who shall display or cause or permit to be displayed at public entertainment, public meeting, reunion, or in such parade, procession, or review, or who shall expose or cause to be exposed to public view of any flag, banner, emblem, or device used during the late insurrection in the Philippine Islands to designate or identify those in armed rebellion against the United States, or any flag, banner, emblem, or device used or adopted at any time by the public enemies of the United States in the Philippine Islands for the purposes of public disorder or rebellion or insurrection against the authority of the United States in the Philippine Islands, or any flag, banner, emblem, or of the Katipunan Society, or which is commonly known as such, shall be punished by a fine of not less than 500 pesos nor more than 5,000 pesos, or by imprisonment for not less than 3 months nor more than 5 years, or by both such fine and imprisonment in the discretion of the law, the court. Section 3. It shall be unlawful for any person to expose or cause to permit or to be exposed to public view in his own premises, or to expose or cause to be exposed to public view either in his own premises or elsewhere to display or cause to be displayed at any or in any parade, procession, or review, or for any person having charge of such public entertainment, meeting, or reunion, or of such permit to be displayed or exposed to public view any flag or banner the use or display of which is prohibited by executive order of the Governor-General. Any person who shall violate the provisions of this section shall be punished by a fine of not less than 500 pesos nor more than 5,000 pesos, or by imprisonment for not less than 3 months nor more than 5 years, or by both such fine and imprisonment in the discretion of the court. Provided, however, that nothing in this section contained shall be construed to authorize the Governor-General to permit the use or display of any flag, banner, emblem, or device whose use, display, or exposition to public view is prohibited by the preceding sections of this Act. Section 4. Any person who shall wear, use, or expose to public view in any parade, procession, or review any uniform or dress, or part thereof, adopted or used during the late insurrection in the Philippine Islands to designate or identify those in armed rebellion against the United States, or any uniform or dress or part thereof, adopted or used at any time by the public enemies of the United States in the Philippine Islands for the purposes of public disorder or of rebellion and insurrection against the authority of the United States in the Philippine Islands shall be punished by a fine of not less than 500 pesos nor more than 5,000 pesos, or by imprisonment for not less than 3 months nor more than 5 years, or by both such fine and imprisonment in the discretion of the court. Another legislation was enacted on November 12, 1902, as a tool which was utilized by American authorities to extinguish any remaining revolutionary activities in the Philippines. Act Number 518, also called the Brigandage Law of 1902. What is the word brigandage? Brigandage was defined in the legislation as an act involving 3 or more persons of conspiring together to form a band of robbers for the purpose of stealing, brigands. In addition, were also identified as men who roam over the country armed with deadly weapons. Brigandage law is an act defining highway robbery or brigandage and providing for the punishment therefor. There are 4 sections under brigandage law by authority of the United States, be it enacted by the Philippine Commission that Section 1. Whenever 3 or more persons conspiring together shall form a band of robbers for the purpose of stealing carabao or other personal property by means of force and violence, and shall go out upon the highway or roam over the country, armed with deadly weapons for this purpose, they shall be deemed highway robbers or brigands, and every person engaged in the original formation of the band or joining it thereafter shall, upon conviction thereof, be punished by death or imprisonment for not less than 20 years in the discretion of the court. Section 2. To prove the crime described in the previous section, it shall not be necessary to adduce evidence that any member of the hand has in fact committed robbery or theft, but it shall be sufficient to justify conviction thereunder. From the circumstances, it can be inferred beyond reasonable doubt that the accused was a member of such an armed band as the described in said section. Section 3. Persons guilty of the crime defined in Section 1 may be punished therefore in the court of first instance in any province in which they may be taken or from which they may have fled. Section 4. Every person knowingly aiding or abetting such a band of brigands as the described in Section 1 by giving them information of the movement of the police or constabulary, or by securing stolen property from them, or by procuring supplies of food, clothes, arms, or ammunition, and furnishing the same to turn, shall upon conviction be punished by imprisonment for not less than 10 years and not more than 20 years. Excerpts of the Philippine Organic Act of 1902 or Cooper Act. In 1902, the Philippine Organic Act, also known as the Cooper Act, was passed by the United States Congress. This law, primarily authored by Henry A. Cooper, a member of the United States House of Representatives from Wisconsin, became the basic law of the colonial government in the Philippines and was the basis of different societal changes such as Filipino participation in government. Deemed as the constitution for the colony, the law provided for a legislative body known as the Philippine Assembly, which was to be occupied by elected Filipino statement. Likewise, the act secured a number of rights for the Filipinos and gave them the privilege of sending two non-voting resident commissioners to the U.S. Congress starting in 1907. Pablo Ocampo and Benito Legarda, both graduates of University of Santo Tomas, were the first holders of the position. Other pertinent issues to the Philippines such as those relating to natural resources, including its usage and conservation, are also discussed in the law. Philippine Organic Act is an act temporarily to provide for the administration of the affairs of civil government in the Philippine Islands and for other purposes. Here are the important portion of the Cooper Act. Section 4. That all inhabitants of the Philippine Islands continuing to reside therein who were Spanish subjects on the 11th day of April, 1899, and then resided in the Philippine Islands, and their children born subsequent thereto, shall be deemed and held to be citizens of the Philippine Islands, and as such entitled to the protection of the United States, except such as shall have elected to preserve their allegiance to the Crown of Spain in accordance with the provision of the Treaty of Peace between the United States and Spain signed at Paris December 10, 1898. Section 5. That no law be enacted in said islands which shall deprive in person of life, liberty, or property without due process of law, or denied to any person therein the equal protection of the laws. That in all criminal prosecutions the accused shall enjoy the right to be heard by himself and counsel, to demand the nature and cause of the accusation against him, to have a speedy and public trial, to meet the witnesses face to face, and to have compulsory process to compel the attendance of witnesses in his behalf, that no person shall be held to answer for a criminal offense without due process of law, and no person for the same offense shall be twice put in jeopardy of punishment, nor shall be compelled in any criminal case to be a witness against himself, that all persons shall before conviction be bailable by sufficient sureties except for capital offences, that no law impairing the obligation of contract shall be enacted, that no person shall be imprisoned for debt, that the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion, insurrection, or invasion, the public safety may require it, and either of which events the same may be suspended by the President or by the government with the approval of the Philippine Commission. Wherever during such period the necessity of such suspension shall exist, that no ex post facto law or bill of attainder shall be enacted, that no law granting a title of nobility shall be enacted, and no person holding any office of profit or trust in said islands shall without the consent of the Congress of the United States accept any present emolument, office, or title of any kind whatever from any king, queen, prince, or foreign state, that excessive bail shall not be required, nor excessive fines exposed, nor cruel and unusual punishment inflicted, that the right to be secure against unreasonable searches and seizures shall not be violated, that neither slavery nor involuntary servitude, except as punishment for crime whereof of the parties shall have been duly convicted, shall exist in said islands, that no law shall be passed abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances, that no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof, and that the free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed, that no money shall be paid out of the treasury except in pursuance of an appropriation by law, that the rule of taxation in said islands shall be uniform, that no private or local bill which may be enacted into law shall embrace more than one subject, and that subject shall be expressed in the title of the bill, that no warrant shall issue but upon probable cause, supported by the oath or affirmation, and particularly describing the place to be searched and the person or things to be seized, that all money collected and any tax levied or assessed for a special purpose shall be treated as a special fund in the treasury and paid out for such purpose only. Section 6. That whenever the existing insurrection in the Philippine Islands shall have ceased and a condition of general and complete peace shall have been established therein, and the fact shall be certified to the President by the Philippine Commission, the President, upon being satisfied thereof, shall order a census of the Philippine Islands to be taken by said Philippine Commission. Such census in its inquiries relating to the population shall take and make so far as practicable full report for all the inhabitants of name, age, sex, race, or tribe, whether native or foreign born, literacy in Spanish, native dialect or language, or in English, school attendance, ownership of homes, industrial and social statistics, and such other information separately for each island, each province and municipality or other civil division, as the President and said Commission may deem necessary, provided that the President may, upon the request of said Commission in his discretion, employ the service of the Census Bureau in compiling and promulgating the statistical information above provided for, and may commit to such bureau any part of portion of such labor as to him may seem wise. Section 7. That 2 years after the completion and publication of the census, in case such a condition of general and complete peace with recognition of the authority of the United States shall have continued in the territory of said islands not inhabited by Moros or other non-Christian tribes, and such facts shall have been certified to the President by the Philippine Commission. The President, upon being satisfied thereof, shall direct Commission to call, and the Commission shall call a general election for the choice of delegates to a popular assembly of the people of said territory in the Philippine Islands, which shall be known as the Philippine Assembly. After said assembly shall have convened and organized, all the legislative power heretofore conferred on the Philippine Commission in all the parts of said islands not inhabited by Moros or other non-Christian tribes shall be vested in the legislature consisting of 2 houses, provided that no province shall have less than 1 member, and provided further that provinces entitled by population to more than 1 member may be divided into such convenient district as the said Commission may deem best. Public notice of such division shall be given at least 90 days prior to such election, and the election shall be held under rules and regulations to be prescribed by law. The qualifications of electors of such election shall be the same as is now provided by in law in case of electors in municipal elections, and the members of assembly shall hold office for 2 years and the first day of January next following their election, and their successor shall be chosen by the people every second year thereafter. No person shall be eligible to such election who is not qualified elector of the election district in which he may be chosen, owing allegiance to the United States and 25 years of age. The legislature shall hold annual sessions commencing on the first Monday of February in each year and continuing not succeeding 90 days thereafter, provided that the first meeting of the legislature shall be held upon the call of the government within 90 days after the first election, and provided further that if the termination of any session of appropriations necessary for the support of government shall not have been made, an amount of equal to the sums appropriated in the last appropriation bills for such purposes shall be deemed to be appropriated, and until the legislator shall act in such behalf, the treasurer may, with the advice of the governor, make the payments necessary for the purposes aforesaid. The legislature may be called in special session at any time by the civil government for general legislation or for action on such specific subject as he may designate. No special session shall continue longer than 30 days, exclusive of Sundays. The assembly shall be the judge of the elections, returns, and qualifications of its members. A majority shall constitute a quorum to the business, but a smaller number may adjourn from day to day and may be authorized to compel the attendance of absent members. It shall choose its speaker and other officers, and the salaries of its members and officers shall be fixed by law. It may determine the rule of its proceedings, punish its members for disorderly behavior, and with the concurrence of two-thirds expel a member. It shall keep a journal of its proceedings, which shall be published of the yeas and nays of the members on any question shall, on the demand of the one-fifth of those present, be entered on the journal. Section 8. That at the same time with the first meeting of the Philippine legislature, the biennially thereafter, there shall be chosen by said legislature, each house voting separately, two resident commissioners to the United States, who shall be entitled to an official recognition as such by all departments upon presentation to the President of the certificate of election by the civil governor of said islands, and each of whom shall be entitled to a salary payable monthly by the United States at the rate of $5,000 per annum, and $2,000 additional to cover all expenses, provided that no person shall be eligible to such election who is not a qualified elector of said islands, owing allegiance to the United States, and who is not 30 years of age. Section 9. That the Supreme Court and the Courts of First Instance of the Philippine Islands shall possess and exercise jurisdiction as heretofore provided, and such additional jurisdiction as shall hereafter be prescribed by the government of said islands, subject to the power of said government to change the practice and methods of procedure. The municipal courts of said islands shall possess and exercise jurisdiction as heretofore provided by the Philippine Commission, subject in all matters to such alteration and amendment as may be hereafter enacted by law, and the Chief Justice and Associate Justices of the Supreme Court shall hereafter be appointed by the President, by and with the advice of consent of the Senate, and shall receive the compensation heretofore prescribed by the Commission until otherwise provided by Congress. The judges of the Court of First Instance shall be appointed of the civil governor by and with the advice of consent of the Philippine Commission, provided that the admiralty jurisdiction of the Supreme Court and Courts of First Instance shall not be changed except by act of Congress. Section 10. That the Supreme Court of the United States shall have jurisdiction to review, revise, reverse, modify, or affirm the final judgments and decrees of the Supreme Court of the Philippine Islands in all action, cases, causes, and proceedings now pending therein, or hereafter determined thereby, in which the Constitution or any statute, treaty, title, right, or privilege of the United States is involved, or in causes in which the value in controversy exceeds $25,000, or in which the title or possession of real estate exceeding the value of $25,000, to be ascertained by the oath of either party or of other competent witnesses, is involved or brought in question, and such final judgments or decrees may and can be reviewed, revised, reversed, modified, and affirmed by said Supreme Court of the United States on appeal or rate of error by the party aggrieved, in the same manner, under the same regulations, and by the same procedure, as far as applicable, as the final judgment of decrees of the Circuit Courts of the United States. Section 12. that all the property and rights which may have been acquired in the Philippine Islands by the United States under the Treaty of Peace with Spain signed December 10, 1898, except such land or other property as shall be designated by the President of the United States for military and other reservations of the government of the United States, are hereby placed under the control of the government of said islands, to be administered for the benefit of the inhabitants thereof, except as provided in this act. Section 13. That the government of the Philippine Islands, subject to the provision of this act and except as herein provided, shall classify according to its agricultural character and productiveness, and shall immediately make rules and regulations for the lease, sale, or other disposition of the public land other than timber or mineral lands, but such rules and regulations shall not go into effect or have the force of law until they have received the approval of the President, and when approved by the President, they shall be submitted by him to Congress at the beginning of next ensuing session thereof, and unless approved, disapproved, or amended by Congress at said session, they shall, at the close of such period, have the force and effect of the law in the Philippine Islands, provided that a single homestead entry shall not exceed 16 hectares in extent. That the Section 14. That the government of the Philippine Islands is hereby authorized and empowered to enact rules and regulations and to prescribe terms and conditions to enable persons to perfect their title to public lands in said islands, who, prior to the transfer of sovereignty from Spain to the United States, had fulfilled all or some of the conditions required by the Spanish laws and royal decrees of the Kingdom of Spain for the acquisition of legal title thereto, yet failed to secure conveyance of title, and the Philippine Commission is authorized to issue patents without compensation to any native of said islands, conveying title to any tract of land not more than 16 hectares in extent, which were public lands and had been actually occupied by such native or his ancestors prior to and on the 13th of August, 1898. Section 15. That the government of the Philippine Islands is hereby authorized and empowered, on such terms as it may prescribe by general legislation, to provide for the granting or sale and conveyance to actual occupants and settlers and other citizens of said islands such parts and portions of the public domain other than timber and mineral lands of the United States in said islands as it may deem wise, not exceeding 16 hectares to any one person, and for the sale and conveyance of not more than 1,024 hectares to any corporation or associate of persons, provided that the grant or sale of such lands, whether the purchase price be paid at once or in partial payment, shall be conditioned upon actual and continued occupancy, improvement, and cultivation of the premises sold for a period of not less than 5 years, during which time the purchaser or grantee cannot alienate or encumber said land or the title thereto, but such restriction shall not apply to transfer of rights and title of inheritance under the laws for the distribution of the estates and descendants. Section 16. That in granting or selling any part of the public domain under the provision of the last preceding section, preference in all cases shall be given to actual occupants and settlers, and such public lands of the United States in the actual possession or occupancy at any native of the Philippine Islands shall not be sold by said government or to any other person without the consent thereto of said prior occupant or settler first hand and obtained, provided that the prior right hereby secured to an occupant of land who can show no other proof of title than possession shall not apply to more than 16 hectares in any one tract. Section 17. The timber trees, forests, and forest products on lands leased or demised by the government of the Philippine Islands under the provision on this act shall not be cut, destroyed, removed, or appropriated except by special permission of said government and under such regulation as it may prescribe. All monies obtained from lease or sale of any portion of the public domain or from license to cut timber of the government on the Philippine Islands shall be covered into the Insular Treaty and be subjected in all appropriation for insular purposes according to law. Section 18. That the forest laws and regulations now in force in the Philippine Islands with such modifications and amendments as be made by the government of said islands are hereby continued in force, and no timberlands forming part of the public domain shall be sold, leased, or entered until the government of said islands, upon the certification of a forestry bureau that said lands are more valuable for agriculture than for forest uses, shall declare such lands so certified to be agricultural in the character, provided that the said government shall have the right and is hereby empowered to issue license to cut, harvest, or collect timber and other forest products on reserved or unreserved public lands in said islands in accordance with the forest laws and regulations herein before mentioned and under the provision of this act. And said government may lease land to any person or persons holding such licenses sufficient for a mill site not to exceed 4 hectares in extent, and may grant rights of ways to enable such person or persons to get access to the lands to which such license apply. Section 19. That the beneficial use shall be the basis, the measure, and the limit of all rights to water in said islands, and the government of said islands is hereby authorized to make such rules and regulations for the use of water, and to make such reservations of public lands for the protection of the water supply, and for other purposes not in conflict with the provisions of this act, as it may deem best for the public good. Section 20. That in all cases public lands in the Philippine Islands available for minerals shall be reserved from sale except as otherwise expressly directed by law. Section 21. That all valuable mineral deposits in public lands in the Philippine Islands, both surveyed and unsurveyed, are hereby declared to be free and open to exploration, occupation, and purchase, and the land in which they are found to occupation and purchase by citizens of the United States or of said islands, provided that when on any lands and said islands entered and occupied as agricultural lands under the provision of this act, but not patented, mineral deposits have been found, the working of such mineral deposits is hereby forbidden until the person, association, or corporation who or which has entered and is occupying such lands shall have paid to the government of said islands such additional sum or sums as will make the total amount paid for the mineral claims or claims in which said deposits are located equal to the amount charged by the government for the same as mineral claims. Section 86. That all laws passed by the government of the Philippine Islands shall be reported to Congress, which hereby reserves the power of the authority to annul the same, and the Philippine Commission is hereby directed to make annual report of all its receipts and expenditures to the Secretary of War.